As they're being seated, I'd like to introduce our second panel of witnesses. Charles Moody is the chairman of the board and soon will serve as interim CEO of Fairview Health Services. He's also the former CEO of International Dairy Queen and recently became the owner of the Minnesota textiles firm, Faribault Woolen Mills Company. Mr. Moody began his career working at Edina-based Dairy Queen in 1987. Greg Kazarian has been Senior Vice President of Accretive Health since January of 2004. He previously served as Accretive's General Counsel. Prior to joining Accretive, Mr. Kazarian spent 16 years with the law firm of Peterson and Haupt, where he worked on issues related to employment, intellectual property, creditors' rights, dispute resolution, and outsourcing. Thank you for joining us, Mr. Moody and Mr. Kazarian. I know that it's not an easy thing to take time away from your schedules to participate in this hearing and to give testimony. I really do appreciate your time. Mr. Moody, please go ahead with your testimony.
Right. Good morning, Chairman Franken. My name is Charles Moody, and I am the chair of the Fairview Health Services Board of Directors, and will serve as Fairview's interim chief executive officer beginning August 1st, 2012. Thank you for inviting me to be here today with you. As you know, Fairview has had a long and strong reputation of providing exceptional health care to the communities we serve. Fairview's reputation is built on a long track record of quality care and contributions to the local community. The issues that have come to the fore recently have been challenging for our employees, physicians, and leaders. And most importantly, we know that these issues created challenges for some of our patients who do not feel that they were treated with respect and dignity. To those patients, I offer my personal apology and firm commitment on behalf of the entire Fairview organization to regain your trust. The Minnesota Attorney General's compliance review includes several examples from patients and employees of business practices that are not in keeping with Fairview's values and code of conduct. And while Fairview is not a defendant in any Attorney General lawsuit, I can assure you that we are cooperating with the Attorney General's office in order to reassure our patients that we are committed to compliance with all laws and regulations, and above all else, improving patient care. Fairview has taken action to remedy the issues that have been identified prior to the Attorney General's suit. Fairview terminated its work with Medical Financial Solutions, a part of Accretive Health, on January 6, 2012, because of their failure to comply with the State Attorney General's billing and collection agreement. In addition to terminating our agreements with Accretive Health, we also have initiated better approaches for escalating patient, employee, and physician concerns so that they receive prompt attention. We are reviewing and revising our training tools to ensure each patient interaction reflects Fairview's core values. We've stopped collecting past due balances and co-insurance payments in emergency departments, and we're reviewing emergency department and registration workflow processes. We also have reallocated resources to functions within Fairview that handle refund and credit balance processes to ensure prompt repayment of amounts due to patients. In short, we are shouldering our share of the responsibility and taking actions to address concerns for our patients, employees, and physicians. Fairview's first priority is and always will be the care for our patients. All of our employees, physicians, leaders, and even board members are dedicated to patient well-being. The Fairview team strives to deliver exceptional care at all times in a respectful manner and in compliance with the relevant laws and regulations. Moving forward, Fairview leadership and governance members are going to do a better job of listening and acting upon patient and staff concerns and recommendations. And as Fairview transitions to a new leadership, I can assure you that governance will now have our renewed commitment to carry this forward. Thank you for inviting me here today, and I welcome your questions.
Thank you for your testimony, Mr. Moody. Mr. Kazarian, thank you for being here. I will note that I asked Accretive CEO to participate in this hearing, but she was unable to do so. But I understand that you are the head of compliance for Accretive and probably are the best person to talk about these issues that we're discussing today. So I'm glad that you're here, Mr. Kazarian. Thank you. Please go ahead with your testimony.
Thank you, Senator. Good morning. My name is Greg Kazarian, and I'm the Senior Vice President of Operations and the Corporate Responsibility Officer at Accretive Health. I came to Accretive Health in 2004 because I believed in the company's mission and its vision for helping patients and hospitals navigate the challenge of rapidly rising healthcare costs. I came to Accretive Health because I saw a tremendous opportunity to make improvements in a broken and struggling healthcare system. I'm 49 years old, and I have a wife and 3 children. Between us, we have 4 aging parents, 2 of whom live across my backyard. As a family, we've experienced all of the usual medical issues that families experience every day. I know firsthand how important high-quality, compassionate care is. And I know firsthand how important it is that patients understand what insurance and public assistance they're eligible for, as well as their own financial obligations for their medical care. There are 3 things I'd like to cover quickly in these opening remarks. First, I want to thank you, Senator. Thank you for inviting us to speak with you today, for the time your staff has spent with us discussing these important issues, for your willingness to listen, and for your efforts to have an open and honest discussion as to how healthcare can and should be improved. I thank you on behalf of myself as well as the 3,000 employees who work at Accretive Health. Approximately 150 of those employees live and work right here in Minnesota. These individuals work as nurses, financial counselors, and social workers. Over 50 of them have chosen to attend this hearing voluntarily on their own time today. Senator, it's important that the work of these trusted, dedicated colleagues be understood and appreciated, and that is something I'm going to try to achieve in our time today. Today I want to explain what we at Accretive Health do. I suspect that many people in this room had never heard of Accretive Health before the last few weeks. Unfortunately, we've been portrayed in a way that distorts and misrepresents our business and our work. True debt collection is less than 1% of what we do. The core of what we do every day, everywhere we work, is help hospitals find all available coverage for patients and ensure that insurance companies and government programs pay the hospitals the money they're owed for the care they provide. For example, we go to bat for patients who've been denied insurance coverage for pre-existing conditions, and we get those claims paid. We advocate for patients when their insurance company refuses coverage for conditions that are medically necessary, and we get those claims paid. We fight to get patients who qualify onto disability so that they can get coverage for the care they need. Over 95% of the revenue we secure for hospitals come from insurance companies or government payers. As part of our work, we also help hospitals collect the amounts due to them from patients. And we help the patients themselves understand the coverage they have and how it's going to respond to that episode of care and the benefits they may be eligible for. This is information patients want to know and need to understand. We're proud of the work we do, and particularly proud of the fact that we've helped more than 250,000 formerly uninsured people obtain coverage for their care. 16,000 of those people right here in Minnesota. 16,000 people who didn't know they had coverage for the care they were receiving were connected to that coverage so it would pay for their claims. And for those who cannot pay and for whom we cannot find another source of coverage, we assist hospitals in getting those patients charity care and other financial counseling, including discounts and payment plans. The work of our quality and total cost of care program is another point of great pride for us at Accretive Health. In this groundbreaking program, we help care providers identify and reach out to the sickest patients they serve and coordinate their care and services to provide it to them in ways that help improve their health care and reduce the need for costly emergency room visits. For example, by connecting social workers with homebound patients or patients who are vision impaired, we can create safer living environments that reduce accidents. For patients with insufficient social networks and those with memory problems, we coordinate transportation to pharmacies so those patients don't get sicker. I sincerely hope to have an opportunity to talk today in more detail about this very important part of our work. The final comment I would like to make is perhaps the most important. Accretive Health is a company that believes our mission is to help patients and strengthen the financial viability of the not-for-profit hospitals we serve. We take seriously the allegations that have been raised by the Attorney General and appreciate the opportunity to have this dialogue and set the record straight. As a company, we firmly believe that even one unsatisfied patient is one too many. Let me be clear. Many of the allegations we've heard this morning and in the press are deeply troubling. And if they are true, they would be flatly inconsistent with Accretive Health policies, our training, and our values. To any patient who experienced any interaction with us or with our Fairview colleagues that lacked compassion and professionalism, we sincerely apologize.
Thank you.
Again,
have
we
to
thank
wrap
you,
up.
Senator, for inviting us to have this dialogue, and I look forward to your questions.
Thank you so much, both of you, Mr. Moody, Mr. Kazarian. Mr. Moody, I understand that you are in the process of transitioning to become Fairview's interim CEO, so that you may not know every detail of the day-to-day workings of the hospital or what happened. But as chairman of the board, I hope you can answer a few questions. And if there's something you need to check on, I hope that you'll follow up with me. Fairview has been around for over 100 years, right?
That's correct.
As far as you know, in those 100 years, has Fairview ever had problems like those that we're discussing today?
I think as the Attorney General referenced back in 2005 when the agreements were entered into before, that Fairview was part of the group that had had challenges and issues with the Attorney General at that time.
Okay, thank you. I was very disturbed by Mr. Moody, by the allegations that Accretive was badgering patients in Fairview's emergency room and in the neonatal intensive care unit to ask for prepayment and to collect on debts. What was your first reaction to these allegations?
I think all of us within Fairview love our culture and our commitment to our patients. And anytime both our patients and our employees are not in a comfortable situation, that's just very disconcerting.
If these allegations turn out to be true, would they violate any part of Accretive's contract with Fairview?
I'm not the legal expert to know exactly as to what the violations would do. My guess is that in many respects, if what has been reported is actual and truth, that would require an issue as it relates to any agreement or any activity with Accretive.
Okay, thank you. Mr. Moody, the Attorney General's report discusses what she calls a culture clash between Accretive and Fairview. She cites emails in which Fairview physicians expressed their discomfort with certain activities. Did Fairview perceive a culture clash between Fairview and Accretive? What steps did Fairview take to address these concerns at the time? And did Fairview staff address them directly with Accretive?
My understanding is that staff did elevate concerns to their appropriate managerial reports, and that was passed along. As to how high that was passed along is still something that we're needing to try to dive into and gain greater understanding of. But there's no doubt that there was a culture change and an uncomfortness that both went to our employee group as well as to our patients, and that's a troubling situation.
Mr. Moody, can you tell me what steps Fairview has taken to protect patients from inappropriate debt collections? How have Fairview's procedure changed since Fairview became aware of the Attorney General's investigation and the alleged activities of Accretive? And in Fairview's view, what is the responsible way, or the Minnesota way, if you will, to collect payment from patients?
I think the first and foremost is to make sure that whatever our procedures are, is that it's within the rules and laws of the state. And so in that respect, it's very vitally important that we uphold those laws as we go forward. As it relates to changes, we have now taken all of that collection in-house, and we have dedicated our team to new training and to new approaches and new scripting to make sure that we are upholding that as we go forward in time. I will do my darndest as far as what is needed to make sure that we steward this thing appropriately and guide it to a point where our patients feel that we are being both good stewards and managers of our resources, but also providing exceptional quality care.
Thank you. Mr. Kazarian, in its response to my letter, Accretive said that, quote, while the revenue cycle employees in the call center working to collect payments from patients typically refer to themselves as patient financial advisors or debt recovery specialists, these employees also may have from time to time identified themselves as financial counselors. Now, all these terms, patient financial advisor, debt recovery specialist, financial counselor, seem misleading to one degree or another. Shouldn't the people in the call center disclose at the outset that they are debt collectors calling to collect a debt?
Senator, there's two aspects of work in that call center, and I'm in full agreement with you with respect to those people who are collecting on age debt that is in default, which is the way the Fair Debt Collection Practice Act defines it. In healthcare billing,
maybe we should talk about changing.
yeah,
Yeah.
and we might. And I, you know, I've spent 7 years of my life in this company working on these issues that I talked about in my opening statements, and we are.
Well, how does Accretive determine when a debt is in default?
Actually, Accretive doesn't do that. The hospital policies will typically dictate that. In most instances, it'll be deemed in default at anywhere from 120 to 180 days after the date of statement of service. And the unique issue that you have, the reason we...
You're saying the hospital does it, but don't you, on all of revenue cycle issues, don't you control what the hospital does? That's what it says in your SEC filing.
No, Senator, that's not accurate. I can get to the reconciliation of the SEC filing if you'd like to, but what our contracts all provide is that we will operate in a manner consistent with the hospital's policies and procedures on all the areas that affect the services we provide. So if the hospital says that a debt is in default and to be referred for follow-up, that's what we adhere to.
Okay, it just seems like it's a legal technicality. Most people think of debt as money that they owe to be collected.
Yeah, I understand that, Senator, and that's why I'd like to talk a minute about an area where I think that there's more thought to be provided. In healthcare, we have this unique situation where the patient who's receiving the care, absent some dialogue with somebody, doesn't know what they're going to owe. So if you have, when my son went to the emergency room and then got his knee surgery, we didn't know what our deductible was, what our co-insurance share might be, and unless somebody sits down and talks to you about how Blue Cross is going to handle that care, what they're going to charge, you don't know.
I think I was talking more about the call centers.
Well, and so now, in the call center, there's a concept in healthcare called early out vendors or pre-collect. And what that's talking about is those financial advisors. These are people, if I send that balance and call a patient and say, you've been referred to debt collection 30 days after receive the statement, then Fairview and hospitals all across Minnesota are going to get complaints that that's been escalated prematurely. Why did you send me for debt collection? I just had questions that I didn't understand the bill. So the reason the scripts and the language is different for earlier debt than later debt is because we recognize the first thing patients want to do, and I think your bill actually contemplates it, is understand that the amount that you think is due is an amount I understand, and once we agree on that, then we can talk about how to take care of it. So that's the reason for the different language around a call that's early, where the obligation might not be understood.
I understand. I mean, I was kind of referring to calls that were a little bit later in the cycle, but let me move on. Mr. Kazarian, in your letter to me, you say that revenue cycle employees, this is a quote, revenue cycle employees work to communicate with patients with the greatest possible compassion. Now, I have to say one of the most disturbing documents I've seen in this investigation is an email from an Accretive revenue cycle employee who describes patients as deadbeats and plebeians, and who said, and these are his words, that he, quote, really takes the approach of being stern and calling people out for being stupid, because if they keep hearing it, they may eventually realize their stupidity and possibly feel just a hint of guilt for being such a schmuck, end quote. And this is the part of the email that I can quote in an open hearing. Believe it or not, most of what he says in the email, or a lot of what he says in the email, is even worse. Now, obviously, what was written here doesn't square with anyone's notion of compassion. So I have several questions about this email. First, when and how did you become aware of this email?
We became aware of it in gathering documents that we'd been asked to gather in response to what was a collaborative dialogue we were trying to engage in with the Attorney General's office. She'd asked for us to voluntarily produce some documents, and we were in that process.
If you didn't really get it till then, what did Accretive do to make sure that its employees were following its policies about communicating with patients?
First, let me deal with one issue with respect to that email and that associate. That language, that attitude does not square with our values. It is not consistent with our values, and that employee was terminated within 24 hours of us discovering that email. So let me just, for everybody here, make it clear that is not who we are, and that's not what we do. What do we do to make sure and to detect somebody like that? We have all of our collectors, we do a quality scoring of 2 calls every day that we listen to, and not just for compliance with law, but for tone, for conduct, for professionalism. If an associate does not reflect our company's values, they will not work in our call center. That's how we listen for it, we troll for it. All of our calls are digitally recorded. A second feedback loop is that if there's ever a patient complaint, it may come to the hospital, it may come to the Better Business Bureau, from whatever, it may come from any source. If there's ever a patient complaint, we can listen to that call, it's digitally recorded, and we can determine whether or not they've acted with the care and compassion we expect.
So I take it that you had listened twice a day to this employee?
We'd listened twice a day to this employee. That tone and attitude hadn't been reflected. Then we took a step further, Senator, and after we discovered this email, I asked our internal audit team to listen to another large group of calls for that employee to make sure that terrible offensive attitude hadn't crept into his exchange with patients on the phone. With the idea that if there was anybody that I needed to affirmatively reach out to as an officer of our company, I wanted to do that.
Doesn't an email like this make you concerned about the culture in the call center? I mean, if an employee works in a setting where he thinks it's okay to send an email like this to his coworkers, doesn't that kind of mean you have a real problem on your hands?
It could, and we looked very closely at that issue. What I was somewhat comforted by was that the employee who received the email was, you could tell by the response, was taken aback and wasn't engaging. It wasn't as if this was an exchange. It was, in fact, you could see in the tone somebody who didn't want to engage in this exchange. We We spend a lot of time at that call center. We have records we've shared with the Department of Commerce that indicate that patients that callers and collectors that don't reflect our values can no longer stay with our company. And we'll keep working at that every day. We listen to those calls, and we believe in our people.
Mr. Kazarian, it seems like Accretive often tries to pass blame off to Fairview. For example, in your written testimony, you say that Accretive, quote, did not control Fairview or its employees, end quote. And you say similar things throughout your response to my letter, things that would lead most readers to believe that Accretive did not have full responsibility for Fairview's revenue cycle. But in reality, isn't it the case that Accretive did assume full responsibility for the management and cost of Fairview's cycle,
Senator,
revenue cycle?
Yeah, we work in our work in a partnership model. At the end of the day, both practically and contractually, if there is any disagreement with any aspect of the revenue cycle work, the final authority sits with Fairview. Now, having said that, I'm concerned if we've left you with that impression. We viewed our work with Fairview as collaborative. We saw it as a shared set of responsibilities. I think what we're trying to simply assure people is that in doing that practical work together every day, we are guided by Fairview's values. And if at any point in time there's an inconsistency between Fairview's value and a particular practice we might be recommending, Fairview's policy and Fairview's values will dictate what we do.
It just seems that time and time again, both in your written testimony and in your letter to me, that you kind of pass off responsibility to Fairview employees, and that you don't take full responsibility for Fairview's revenue cycle. And that's concerning to me because Accretive has said in its SEC filings, in no uncertain terms, that Accretive, and I quote, assumes full responsibility for the management and cost of a customer's revenue cycle. Accretive says that it has, quote, the right to control and direct hospital staffs. It says that, quote, we directly manage our customers' employees engaged in revenue cycle activities, end quote. It even says you can fire the employees. It says this in your SEC filing. It seems to me that Accretive is saying one thing in the SEC filings, that it does assume full responsibility, and that Accretive is saying pretty much the opposite thing in the documents that I got from you and in your written testimony today, that Fairview is responsible. And I just don't get it.
Senator Early, at Fairview, as I've said, Fairview wrote these partnership principles into our agreement. We honored them. We were happy to provide for them. There is language that says we have direct financial responsibility, and that is the case. It is the case that if the cost of providing revenue cycle services to Fairview rose beyond what they had been previously, Accretive Health was fully responsible for.
Well, it's not just for the, I'm sorry to interrupt you there. It says in the filings, assumes full responsibility for the management, not just the cost.
And the only way I can reconcile that, Senator, is the filings are written in a general template form. I mean, they speak to a broad array of agreements. We have 26 agreements that are carefully negotiated over a period of time, and different clients have different objectives in terms of how they want our revenue cycle services to be governed in their agreement. The best way I can reconcile what you read in our agreement with Fairview and what you read there is that it would seem to me the SEC filing is written more broadly, and that in the Fairview agreement, our specific relationship with respect to Fairview is set out there.
Okay, I would just remind you that the SEC filings are what investors, you're a public company, and the SEC filings are there for a reason. so that investors who are investing in Accretive can know what rules it's operating under. And they seem greatly at odds with what happened, with what you wrote to me in response to my questions when I asked, did Accretive employees do this? No, it was Fairview, et cetera, et cetera. So let's move on. In your letter to me, you say that financial counseling was optional for patients. I take that to mean that the patient could choose whether or not to have a conversation with a financial counselor. Is that right?
Correct.
But the scripts that Accretive gave employees to use when collecting payments make it look like those conversations were anything but optional. For example, one script teaches employees how to overcome objections from patients. So my question is, how are patients supposed to know that these conversations were optional if nobody indicated in any way that they were optional?
I don't know the specific scripting that you're referring to, and there's a lot of scripting to different scenarios. But what I would say to you is that at the top of every one of our scripts, around patient care is a bold legend in red at Fairview that says not only are patients never to be denied service for non-payment, they're never to be given the impression that service would be denied for non-payment. The role of these conversations is to help patients find a way to resolve their contractual obligations, but more importantly, to educate them about these responsibilities. The information below is to be understood only in that context. So Senator, again, I said in my opening statement, we will strive to be better every day. But what we believed we communicate in our training is that balance of issues.
I understand that disclaimer was there, or you say it was there. The scripts that I saw that were produced by the AG's office do not have any disclaimers to the patients. I mean, that there was no way that the patients were told that the conversation was optional in the scripts. So how do you explain that? I mean, in other words, one thing to put something instructing, in red, bold, okay, this is our policy, but then to give them a script that doesn't have a disclaimer saying, by the way, you don't have to have this conversation with me right now. It seems, how does the patient supposed to know this requirement, which is that they know that this is an optional conversation?
Senator, I think the patient should affirmatively be given that information, and I will look at our scripting, and I will make sure that affirmative language is explicit in multiple ways across the scripting. I take your point, which is that it is important. It is the absolute intent that these conversations are had at a time when patients are ready to receive them, and if we can make our scripts better, then we'll get at that work tomorrow.
Okay, thank you very much. Mr. Kazarian, I'm concerned that Accretive's employees had access to more protected health information than they needed in order to perform their duties. In Accretive's response to my letter, Accretive says that it developed a software tool to restrict its employees' access to just a handful of data points. These included things like the patient's name and contact information, the person financially responsible for the patient's care, the date of service, and a general description of the diagnosis code. It seems to me that that would be all that Accretive employees would need in order to collect debts or do that part of the job. But Accretive's response to my letter says that Accretive did not even begin to implement this software until 8 months into the contract with Fairview, that the tool was not even operational until February of 2011, which is about a year into the contract, and even that some revenue cycle employees continued to have access to Fairview's complete patient files for a full year after that. Now that begs 4 questions. First, why did Accretive wait until 8 months into its contract to begin limiting its employees' access to protected health information?
That's perhaps a bit of a misperception. We had a comprehensive plan to assure that patients working with Fairview only had that access to that health information minimally necessary to do their job. I believe that the portion of our response you're referring to relates to activities in the Kalamazoo Collection Center. The Kalamazoo Collection Center didn't start serving Fairview patients until I believe August or September of 2010. So that was part of the lag. And then you had a mechanism, you had to decide how you were going to have people access that information. Because the legacy system, I think it was called PAS, at Fairview, didn't allow for the parsing of data as precisely as we would have wanted, we had to build a custom, if you will, frame to receive that information. So that's without getting too into the weeds
Sure.
about the technology of it, Senator.
Thank you.
That's my understanding of that sequence.
Well, then, why did some revenue cycle employees continue to have full access to patients' protected health information even after the restrictions were put in place?
Yeah, so I'll bifurcate in that answer between people who were doing the work at Fairview on the claim denial and follow-up work, those people that were trying to overturn the denials on pre-existing conditions, those people who were trying to overturn the denials from a payer who said that the procedure lacked medical necessity. I think it's clear that those individuals doing that work have a necessary reason for access to health information because they use it to advocate to get the claim paid. So that's one group of people that had that access authorized by Fairview, and I don't think there's any disagreement that that particular access was appropriate.
Mm-hmm.
In the call center, the approach that was taken was that patients who were calling and wanted more information about their, I don't believe this charge, or I wasn't at the facility on that day, or I thought it was already paid. There's two ways to approach that. One is to push the patient back to the hospital. I'm sorry, you'll have to follow up directly with the hospital. Working with Fairview, we made the judgment that it would be appropriate to have 2 or 3 managers in the Kalamazoo call center with discrete access so that they could handle that escalated patient question and be more responsive. You've asked about things we can think about in the future, and there's an open question as to whether having that escalation, that information necessary to handle that patient query is appropriate. It's permitted today, and that's the discrete purpose for which that would have been used.
Okay, it doesn't seem like it's actually necessary if all that they're disputing is when the procedure was done and what it was. That is the discrete information, the minimum necessary information that anyone would need, and I don't understand why they need access to all their health care information prior to that. I don't quite understand the response, but in related to that, I mean, do you believe that Accretive complied with HIPAA's minimum necessary requirement, which says that covered entities have to restrict their employees' access to protected health information to only that which is needed for the employees to perform their job?
Yes, Senator, I do. We had very clear procedures and authorization mechanisms to make sure that if our patients were being provided access to patient health information, it was that amount minimally necessary to do their work.
Okay. Matthew Doyle was a revenue cycle employee. An unencrypted laptop containing sensitive information about 23,000 Minnesota patients was stolen from his car. And I don't understand why Mr. Doyle had all that information. The law says that Accretive may give its employees, and you just said it does, only the minimum amount of data necessary for them to do their jobs. Why did Mr. Doyle, a revenue cycle employee, have all these data?
So there were two discrete sets of information that were that Mr. Doyle had at the time that his laptop was stolen from his vehicle. The first was the information relative to the work he was doing in claim follow-up, disability applications and processing, and the nature of that work and revenue cycle. The other, there was a discrete data file that he had in connection with his work coming up to speed in our area and in our work in the quality and total cost of care. And
He didn't work in that, though, did he?
no, he did not, sir.
So he would only need that information if he did work in that. I mean, he was in revenue cycle, and you said that you, in your letter back to me on my questions, you said that you gave him that material because he was interested in learning about the QTCC model that you do, but he wasn't an employee for QTCC. I mean, he wasn't, it's not a, knowing this information isn't required unless you actually have that job. And here, this information was left in a laptop in plain view, and there was a smash and grab, as you refer to it, or as it's been referred to, at Seven Corners. He was not a QTCC employee, he was a revenue cycle employee. Okay. Let me move on to the next question. Accretive says it has a policy of encrypting all laptops, and that seems like a common sense policy to me. Right now, the law does not expressly require encryption of all portable protected health information, that is, all protected health information that is contained on laptops and other portable media that are vulnerable to theft, as you had 9 in 2011 laptops stolen. Do you think the law should be updated to require that practice? It is, after all, practice that Accretive says it has in place now.
Yeah, I think that's it's an appropriate change to consider. I would tell you that one of the things that drives people in the healthcare services arena to that standard is that when you apply encryption and you do it, you fit within the safe harbor of the High-Tech Act under HIPAA. And so I'll leave it to you and your colleagues to decide whether it sits better sort of with that regulatory incentive rather than as a matter of law. But one way or another, it is an important standard to drive anybody that's receiving this information to.
Well, thank you, Mr. Kazarian. Should I continue? Okay, we have enough time. I'm just checking on the time. Mr. Kazarian, the Attorney General alleges that patients were charged for the predicted patient share of a service, but that these predictions sometimes were inaccurate. The Attorney General also alleges that Accretive delayed refunding overpayments. In one of the exhibits, I saw an excerpt from a registration handbook. Accretive instructs employees not to notify patients when they're talking to them that they have a credit on their account. Instead, it tells them to say nothing about the credit. Why would Accretive instruct financial counselors not to let the patients know if they had credits on their accounts?
Two answers to that, Senator. First, what ought to be happening is that any patient balance, any patient refund that's due, ought to be remitted and transferred in a check within 30 days of its determination. So the process ought to be that if there's any patient refund due to a patient, that patient ought to receive that patient refund within 30 days. The reason you would do, the reason you wouldn't engage in that in a time of service is because you'd have to coordinate those two processes, and there are times when that identification of a possible balance isn't an actual balance, and so we'd be passing paper back and forth. We found if you focus your energy on getting payments, refunds that are due, and putting that check in the mail, it's the most straightforward way to make sure that the patient knows you refunded that particular amount without the confusion in an already confusing environment.
If they hadn't received a refund after 30 days, would you then tell them?
That's a, let let me take a minute to think about that.
Well, I'm
It's
afraid
a
you're
good-
going to
it's a
have to
good
think
idea.
about that a little later, because we've run out of time for this panel, but I want to thank you, Mr. Kazarian and Mr. Moody, for your testimony and for coming today and answering questions. Thank you very much. I now call the next panel. Thank you.
Thank you for your interest.
Thank you, gentlemen.